Hello and welcome to Bulletin 48. A couple of interesting cases to mention, and also there's a mention of the fact that, as many of you may already have heard, the remote witnessing of documents brought on by COVID have now been made permanent, and I'm sure that will be a welcome development for many reasons, but just worth noting that there's no sunset on those arrangements. Now, so far as the cases are concerned, Brian and Beverage is the first one, and that was an interim application for maintenance under Section 62 of the Succession Act. The lady had urgent need of some medical treatment and so on, and had sought $220,000 to be paid by a certain date, actually 1st of December, and that was resisted. The executors of the estate said, look, they could possibly do 20, or they were going to do 20, but the rest would have to wait till the end of January. The judge wasn't convinced that they couldn't raise the funds, thought that on balance that it was reasonable that an interim order be made, and made it. Interestingly, the estate consisted of $12 million, and there was potential notional estate of about 50 million. So I guess it wasn't unexpected that the court would think that 220 for some medical issues that needed to be attended to wasn't unreasonable, and as I say, made the order. The other case was an application for judicial advice. It highlighted the need when executors are going to take action to recover, in this case, a significant amount of money, about $400,000, from a friend of the deceased who'd done certain work on a website and had been paid for it, and alleged to be a significant overcharge. And the court gave the approval to pursue the claims because counsel said they had substantial prospects of success, and therefore we used to call those a rebedo order, but in effect authorising the executors to take action. That was the main purpose of it, and the desirability of doing it, because the person against whom the claims were being brought said that they had been brought inappropriately because they hadn't sought the court's order or advice or approval to bring the action. The other issue was that the friend concerned had counter-claimed or cross-claimed, and the issue was whether those costs should come out of the estate, the executor, that is, executors should be able to claim against the estate, and the judge said, well, that will be a matter for determination when the cross-claim has been determined. A couple of interesting cases, reminding us, I think, of the need for executors to get approval if they're going to institute proceedings, that is the approval of the court, and also that interim orders for maintenance under Section 62 of the Act are always available, and in appropriate circumstances, those orders will be made by the court. Thank you.